Go ahead.
Mr. President, Your Excellencies, may it please the court. My name is Daniel Ho, counsel for the applicants Umani in Chatter. Join with me is my co-counsel, Ms. Chow Zhen. I will speak first regarding Omari's prosecution of Umani in the issues 1A and 2A found in paragraphs 22 of the facts. Ms. Chow will then address this court on Omari's prosecution of Chatter, the social media intermediary. I will speak for a total of 22 minutes, Ms. Chow for a further 21 minutes, and we respectfully reserve 3 minutes for rebuttal. Your Excellencies, I would like to clarify, I will speak for 21 minutes. Thank you. Your Excellencies, under the International Covenant on Civil and Political Rights and the Universal Declaration of Human Rights, Omari is obligated to protect the human rights of its people. But far from protecting their rights, it has infringed upon them. It sentenced Umani to 2 years imprisonment for making 6 posts on social media. Now, the state of Omari will undoubtedly claim that it did all that pursuant to its margin of appreciation, pursuant to its national security interests. But the European Court of Human Rights and the United Nations Human Rights Committee have made it clear. State control cannot be used. It must ultimately satisfy a 3-part test, that of legality, necessity, and proportionality. And in our submissions, Omari cannot justify the prosecution it has brought against Umani as it fails all 3 limbs of the test. In demonstrating that this is the case, I propose to answer the following questions. First, can Omari prosecute Umani under laws that do not meet minimum standards required by international law? Second, was it necessary to prosecute Umani? And third, was the 2-year imprisonment proportionate? Now, in answering these questions, it will be made clear the entire state apparatus of Omari has acted oppressively towards Umani. With Your Excellency's leave, I will turn to my first submission. Thank you. For a prosecution to be provided by law, the relevant laws must be sufficiently precise to enable individuals to foresee both liability and the types of penalties that may be imposed upon the individual. This was stated by the European Court of Human Rights in the 2011 decision of Editorial Board in Ukraine at paragraph 52, and the 2008 decision of Kafkaris in Cyprus at paragraph 140. Would Umani know when he will be held liable and how he will be punished under the No Hate Act and anti-terrorism and extremism law? And the answer to that is a no. And we say so for 2 reasons. First, the No Hate Act was applied retroactively to posts 1 and 2. Second, the sections 5 and section 6 of the anti-terrorism and extremism law imposes unspecified punishments upon individuals in Omari. I turn to my first contention. Turning to our first contention, and this can be found at paragraph 12 of our written submissions. Your Excellencies, if you turn with me to paragraph 14A and B of the facts. Now, there it provides that post 1 was published in 2009 and post 2 was published in 2010. But at paragraph 10 of the facts, it states that the No Hate Act was only enacted in 2011.
But Counsel, those posts stayed up after the time the law was passed.
Indeed, Judge Bigot, and we recognize the concern. Now, the question is whether or not for the continued existence, whether it could still find liability and therefore not be retroactive. This very precise concept of continued broadcast was in fact discussed in the 2009 decision of Times newspaper in the UK. And while the court did accept that it could be online broadcasts, that case was in the specific context of defamation, which is the common law. But here we're looking at criminal legislation, and the principle against retroactive criminal laws is therefore applicable. We would also note that this is, in fact, indeed the position of the respondents in their written submissions at paragraph 16. Judge Bigot, aside from the fact that their point is unsupported by law, as a matter of logic, the logical conclusion for finding liability on the sheer existence of a post is this: that upon the enactment of the Act, and considering the fact that ignorance of the law is no excuse, an individual must immediately trawl through years of posts to find a single post that might not even offend the No Hate Act.
Counselor, doesn't that go too far though? Because here we have a social media tool which allows for the re-chatting of posts. We don't know in the facts, but it's certainly possible that someone had re-chatted post 1 after the enactment of the law, and so he would then be on notice, might get a notification. Why would that provide a basis for liability?
Indeed, Judge Barr. That question, however, Judge Barr, should be directed to the respondents, because in that instance, the respondents should well go after those people who chat the post. But what we're concerned with here is Umani, and what we say in respect to posts 1 and 2, the very fact that they were published prior to the enactment of the Act is a retroactive application of the law.
Can I just ask a question following on from that point? The applicants are seeking to avail themselves of a free speech right, but that free speech right comes with responsibilities, special responsibilities, and isn't one of those responsibilities that you have to anticipate in this digital age what might happen to a post? You can't just post it and say, well, I've got no responsibilities.
Certainly, Judge Phillips. Indeed, an individual must be mindful of his posts. But at that point in time of publication, when an individual publishes a post and does not know of the relevant laws of the state at that point in time, the state cannot now then turn their backs against the individual and say, we will apply this law to a post retroactively. But in any event, Judge Phillips, even if Your Excellencies are not with me on this point, our second argument is that Sections 5 and Section 6 of the Anti-Terrorism and Extremism Law imposes unspecified punishments. Your Excellencies, this argument can be found at paragraphs 38 and 39 of our written submissions. Now, the other instance of oppression lies in the unspecified penalties imposed by the state. Starting first with Section 5, Your Excellencies, if I may read it out to you, it states, anyone guilty of an offence under the Act shall be liable to criminal or civil punishments as determined by a judging body. Now, what this does is that it imposes the entire gamut of sentences to which a court may legitimately impose upon an individual. Under this circumstance, Umani would not know the specific types of penalties that will be imposed upon him. And this is a flagrant violation of what was stated in the 2011 decision of Editorial Board in Ukraine. Your Excellencies, we would also note that the respondent has provided us no written arguments on this point in their written submissions. Your Excellencies, the reason why this is important, why Section 5 has been confined, is because we see the same broad wording in Section 6 of the Anti-Terrorism and Extremism Law. And what Section 6 does is that at the interim stage, without subjecting the individual to a full trial, a court could impose criminal or civil punishments. This is unduly wide. In fact, Your Excellencies, this is precisely the problem to which the United Nations Special Rapporteur in his 2011 report at paragraph 39 states, and he says that poorly defined anti-speech legislation could silence legitimate speech on the basis that it is not proportionate at all.
So, Counsel, just so I'm understanding, so the only concern you have about the definitions in the law is this penalty provision, whether it's civil or criminal?
Yes, Judge Bickett. And the reason why we say so is because if we then turn to look at Sections 1 of the 2006 UK Terrorism Act, which we note is worded in peri materia to Sections 3 of the Anti-Terrorism and Extremism Law, what the UK has done is at the very least provide a maximum penalty of 7 years imprisonment. But here, the very fact, and under Section 5, that the state can impose criminal or civil punishment imposes the entire gamut of sentences upon the individual.
Can I just interrupt on that point? I mean, the fact is it's not the state that's imposing the penalty, is it? It's the court. And the court should be independent of the state.
Yes, Judge Phillips. But nonetheless, the very fact that the legislation has provided what we would call unfettered discretion upon the court is problematic under this instance. Judge Phillips and Your Excellencies, if you're satisfied with this argument, I will then turn to our second argument as to the necessary need to have prosecuted Umani in the very first place. Mr. President, Your Excellencies, our arguments on this point can be found at paragraphs 14 to 19 and 41 to 46 of our written submissions. Now, Your Excellencies, Umani may be insensitive, he may be crass even, but under no circumstance was there a need to have prosecuted him, as his speech does not rise to the level of prohibited speech under international law.
Counselor, he may have been crass and oppressive and odious, but he was also a government employee, was he not?
Yes, indeed, he was a government employee.
Should the state not be able to control not only its citizenry, but Don't they have,
You're saying that these words don't incite violence. Can we have a look at, for example, post 2?
Certainly. Judge Phillips, we note and we do accept that the words here used are hostile. Calling for the purifications of Mariam and calling the British child killers, these are indeed hostile words. But Judge Phillips, we must also consider the fact that the money here has counterbalanced and deliberately chosen to include elements of exaggeration. For instance, post 1 begins with the words newsflash to give a certain comical effect. Post 3 includes an emoticon, and post 5 uses the terms kaboom, poof. Now these posts indicate that he drafted them, he designed them, not to be read for its literal meaning. And referring then to paragraph 15 of the facts.
Excuse me, is there anything in the record to indicate that you know what his intent was? You have noted, I'm curious what the burden might have been at trial, but when I read these words, things like the economy is on the brink of collapse due to rampant godlessness in the history of the Civil War. We fried them in 74, fly their shameful flag, we will burn some more. Those seem to me to have some, if there is an intent there, it cannot be, we ought to embrace our brethren.
Certainly. Judge Crown, we do accept that here there are indeed words that are very suggestive of ethnic cleansing, hate speech. We do accept that. But the standard and the burden of proof upon the respondent state is to show it beyond a reasonable doubt. This is, in fact, the position of the European Court of Human Rights and also the International Court of Justice. And here, we see that the intention is not a clear one. Although there are these words, it is also intermingled with elements of exaggeration. But if your excellencies are not with me on this point, alternative argument.
Interrupt you one more point just on the wording here, because you're talking about exaggeration, but we then start getting into an area, what does Article 10 in the European Convention or Article 19 on a wider basis, does that protect exaggerated speech or taking it one step further, untrue speech? Is that also protected?
Judge Phillips, to the point of exaggerated speech, this very question was answered in the 2007 decision of Bildender Künstler and Austria. Now in that case, the court noted that the element of satire, by its inherent nature, aims to provoke, incite, and agitate, hence by very inherent nature, is a form of exaggeration. But what the court also stated was that that form of speech was protected. But in our submissions, we do not go so far to claim that Umani here is a satirist. But what we at the very state is that here, there is no clear intention, and that is our submission. With your excellencies, leave out.
I was concerned a bit by what you have in your submission in paragraph 16, the notion that the more artistic the speech, the less likely it is to be intended as hate speech. That strikes me as assertion. I don't know any empirical basis for it. It seems to be a roadmap. The more hateful you want your speech to be, the more artful you ought to craft it. Is that consistent with what you're saying, or why should that persuade us that it was not intended to what it seems to me on its face actually to be intending, which is to lead to disagreements with those who were participants in the Civil War?
Yes, Judge Crown. We would note that the case of Al-Haq in Turkey, what the European Court of Human Rights did note, is that artistic expression should be given more leeway, because the sheer writing of the speech, the literal words, does not mean that the author intended and endorsed those speech, because that is the exploration of themes. The exploration of themes is not an endorsement. But in any event, even if we do accept it here, perhaps he had an intention, the question is whether or not there was a high likelihood to incite discrimination, hostility, or violence, to which I will now turn to. Now, Your Excellencies, we recognize that there are ethnic tensions in the state, there is violence, and there is also a problem of radicalized citizens. This is well stated between paragraphs 1 to 3 of the facts. These very facts, in fact, were also relied heavily upon by the respondent in their written submissions. However, these problems are not unique to America, and what the United Nations has made very clear is what is required is a direct and immediate link between the speech and the possible harm that could eventuate. But we do accept the state can take preventative measures, but they must nonetheless show this causal link. Your Excellencies, we say that there are two reasons here why that link cannot be shown. First, that Omarian society is sufficiently mature and has the mechanisms to respond to the offensiveness of Umani speech. And second, that Umani's posts being run for 5 entire years led to nothing and no violence. Now the first point, Your Excellencies. Referring to paragraph 16 of the facts, we note that there was an outcry against Umani speech. But this is the very mechanism of a democracy. There were individuals engaged in speech to which other people do not agree with, there will be backlash, there will be an outcry. But that is the very reason why we say here, Omarian society is sufficiently mature. And we also refer to paragraph 15 of the facts for that matter. Many commentators did not read his post literally, but took his post to mean that Omarian's rumored use of chemical weapons against the Britons. And this is significant, because at paragraph 1 of the facts it describes that there is technically an armistice between Omaria and Britain. And what we see here is Omaria unsettling the peace between both states. But, Your Excellencies, aside from this point, if we then turn to look at the first post, being published in 2009, the prosecution was only brought about in 2014 at the behest of a newspaper. Your Excellencies, in the case of Applicant in Turkey, what was noted by the European Court of Human Rights is that this factor, the fact that the state takes time to prosecute an individual, is indicative that there is a low likelihood of violence. But seeing that my time is quickly expiring, I will then turn to our final submission. And even if we do accept that here, Umari was engaged in extremist speech, hate speech, speech that should rightfully be prohibited under international law, was the 2 years imprisonment a justified one? Your Excellency, we would note that the respondents have provided us with no specific arguments on this point in their written memorials. In fact, we would then give you 2 cases to consider. Your Excellencies, in the 2008 decision of Legality in France, the European Court of Human Rights upheld France's decision to impose a fine of 1,500 euros upon a French cartoonist who glorified the 9/11 attacks 7 days after the attacks. And more recently, in the 2015 decision of Diodine Mbala in France, the European Court of Human Rights likewise upheld France's decision to impose a $10,000 fine upon the comedian in that case, who was in fact advocating the public insult of Jews. Now, in these 2 decisions, we see that what is consonant with international law is the imposition of a fine. And we can accept that Imani here should well have been imposed with a fine. But in contrast to a 2-year imprisonment, this is not in line with the jurisprudence of the international courts.
Counsel, since you're referencing the Leroy case, the respondents have relied upon the Leroy case for support that Umani's comments could indeed be incitement. How would you distinguish that case?
Indeed, Judge Bigot. We would note that they have relied on the Leroy case to show that satire and prohibited speech are not mutually exclusive, and that we do accept, but nonetheless stands for our proposition here, that even if an individual were prosecuted for the basis of prohibited speech, that it only sounds in fines in international jurisprudence. Indeed, Your Excellencies, if you also turn to cases in which imprisonment have been imposed, there are 2 cases. First, the case of Arslan in Turkey. In that case, what the Turkish court imposed was a 20-month imprisonment, and what the European Court of Human Rights deemed that the 20-month imprisonment was disproportionate. Your Excellencies, this is not the only reason why we say here that Umani's imprisonment was not in line with international jurisprudence. Because, Your Excellencies, if you then consider the fact that the great spectrum of offences relating to violence, speech lies on one end of the spectrum. On the other end of the spectrum, we have individuals engaged with material support to terrorist groups. And what the United Nations Special Rapporteur in his 2011 report notes is that imprisonment can rarely be justified on the sole basis of speech alone. Your Excellencies, I see that my time is up. If I may be given 30 seconds to wrap up.
Councillor, I just want to follow up, if I may, on the point that you've got to, which is, do the applicants think in any circumstances it's justified to send people to prison for speech issues?
We do agree that it is justified, especially if the individual is inciting terrorism. But what we say here is that the lack of intention, the very fact that nobody pays heed to Umani's words, the fact that Omarian society can well engage in the sort of speech that Umani is engaged in, these facts indicate that an imprisonment of 2 years is not consonant with international law.
But
Mr. President?
Councillor, I think your client was not just imprisoned under the Hate Speech Act, it was also imprisoned under a Terrorism Act in this case. So, would you concede that if the terrorism case was properly applied in this case, that it might well be that your client should be sent to prison?
No, Judge Phillips, because it's our position that if the state wishes to prosecute an individual for the incitement to terrorism, they must nonetheless show the 2 elements, intention and high likelihood of discrimination, hostility, or violence. In fact, Judge Phillips, if you then turn to the travel préparatoire of Article 20, it's very clear. The threshold is a high one for the state to prove. Mr. President, Your Excellencies, I add my submissions. If there are no further questions.
President, Your Excellencies, may it please this Honourable Court. My name is Charles Earn, and I am on behalf of the applicant, Chatter. As mentioned earlier by my co-counsel, I will be speaking for 21 minutes on Chatter's liability. Omeria has not only unjustifiably interfered with Umani's rights by prosecuting him, it has also unjustifiably interfered with Chatter's freedom of expression. Like my co-counsel, I propose to answer the following questions, ensuring that Omeria's prosecution of Chatter violates the third limb of the three-part test. First, were the obligations imposed on Chatter necessary? And second, was the $5 million fine imposed on Chatter proportionate? In answering these questions, it will be clear that Omeria had not only acted oppressively and without due regard to Umani's rights, but Chatter's rights as well. I now turn to the first question on whether the obligations imposed on Chatter were necessary, which can be found at paragraphs 27 to 31 and 52 to 57 of our written submissions. We argue that the obligations were oppressive for two reasons. First, they were unduly onerous, and second, they have negative implications on the freedom of expression. I will be dealing with both in turn, starting with how the obligations are unduly onerous because they expect Chatter to exercise preemptive censorship. This means that for Chatter to comply with both the acts, it cannot even allow any illegal content to be published on its platform. We note the idea of preemptive censorship is impracticable, as stated in the 2016 European Court of Human Rights decision of MTE and Hungary, where if I may quote at paragraph 86, it states, "This amounts to requiring excessive and impracticable forethought capable of undermining freedom of the right to impart information on the internet." We note that the respondents have argued at paragraph 28 and 58 of their written submissions that the obligation on Chatter is one of takedown upon user notification.
Well, Councillor, why isn't that correct? I mean, I'm looking here at issue 1B, which you're addressing. Post 2 was taken down. He was suspended in relation to that post, and Chatter was not prosecuted for that post. So, on the one hand, you're advocating that it was unduly burdensome and onerous for Chatter to have to somehow, enforce a restraint on speech, but apparently they satisfied the state by taking down that post and weren't charged for it. They were on notice of Umani's actions. There were complaints as to others. They didn't comply. Why aren't they then liable?
Judge Bach, indeed it is the position that Chatter was not convicted for Post 2, as stated at paragraph 20 of the facts after its suspension of Umani's account. However, there are two factors that can hold against this, because first, Chatter was prosecuted for Post 3, even though the post only remained online for 4 minutes. And what is notable is that Umani was the individual that deleted the post. And these facts can be seen at paragraph 14C and paragraph 1 of the compiled clarifications. And the only way in which Chatter could have prevented facilitation of the post for 4 minutes online is if it preemptively censored and removed Umani's post even before they went online. And hence, the obligation is one of preemptive censorship. In fact, this
Counselor, but you're ignoring the fact that I think in the clarifications, every time that post was rechatted, that actually did persist and remained online. And Chatter apparently didn't act on that.
Judge Bach, that is one possible interpretation, but it is not supported by the express wording of the No-Hate Act. If I may direct Your Excellencies to look at the obligation imposed on Chatter in the No-Hate Act. Chatter was held liable under Section D, which can be found at paragraph 10D of the facts, and it states that Chatter cannot facilitate another statement prohibited under the Act. By hosting Umani's post, Chatter is effectively facilitating his prohibited statements. and hence the only way in which Chatter would not be facilitating his statements were if it preemptively censored his posts even before they were published on the platform. This onerous obligation of preemptive censorship is not just supported by the No Hate Act, but also the express wording of the Anti-Terrorism and Extremism Law. We note that Chatter was prosecuted under Section 3 of the Anti-Terrorism and Extremism Law, which can be found at paragraph 4C of the facts, and it states that Chatter cannot publish or cause or permit another to publish a statement. This effectively criminalizes the publication of a statement, and the only way in which Chatter could have not published Umani's statements was if it exercised preemptive censorship even before the statements were published online. And hence, the conclusion remains the same, that under both the No Hate Act and the Anti-Terrorism and Extremism Law, the obligation that the Omarian government saw fit to impose on Chatter is the very onerous obligation of preemptive censorship. The oppressiveness of such an obligation becomes even more evident when we ask ourselves the question of how could Chatter have complied with the law?
Counsel, so if there were an actual knowledge standard, if that was the way it was interpreted by the courts, is that okay by your analysis?
Judge Bickett, perhaps if the standard was one of actual knowledge of illegality, that can qualify. We note that the respondents have tried arguing in their written submissions that there was actual knowledge of illegality because of user notification and complaints. However, that is simply not the standard of actual knowledge of illegality.
Does it have to be actual knowledge of illegality or actual knowledge of the content, the language in the post?
Our submission is merely because Chatter knows of the post and its existence does not make it any easier for Chatter to have determined the legality of the post, and such an obligation and legal determination should not be placed in the hands of Chatter.
Counselor, there are obligations that are placed on other content hosting companies under U.S. law to at least make a good faith determination as to the substance of content in the fair use context and copyright. So why shouldn't Chatter at least, you seem to say that they can just dismiss it out of hand because it's too high a burden, but they haven't even taken the most minimal steps.
Judge Buck, if indeed the standard is good faith determination, we submit that Chatter has satisfied this obligation, because ultimately, as my co-counsel had earlier proposed, Umani's speech is not a clear case of prohibited speech. Chatter, upon looking at Umani's post, may take into account his persona, the fact that no one has taken him seriously despite his years of posting such statements, and decided, in light of the debate that's happening as stated at paragraph 15 of the facts, to allow the post to exist. And hence, even if Chatter looked at the post, it has dismissed its good faith determination. However, what is crucial is that the obligation that the Omarian government imposes on Chatter is not just one of good faith determination, because according to the express wording of the statutes, it is one of preemptive censorship. And our submission is that such an obligation is onerous and oppressive because Chatter could not have complied with it. There are 4 key facts to characterize what kind of the number of posts and users Chatter has to deal with. First, we know that in Omaria, there are up to 25 million people staying in the country. This means that there are at least several million people using Chatter, given that at paragraph 6, social media is very popular, especially Chatter. And not only that, we note at paragraph 5 that Omaria has free high-speed internet, and it is also one of the highest bandwidth per capita in the world. This means that at any one point in time, Chatter has to preemptively censor many users and many posts that can come out instantaneously. And this makes the obligation very onerous, because what could Chatter have done? Perhaps the respondent might suggest that Chatter could have adopted word filters, but our submission is that this would not help Chatter meet its obligation either.
But Councillor, in the Delphi case, the court had no problem in finding that, notwithstanding that, then you've got to have mechanisms to stop it, and you can't let it sit and then retrospectively try to justify why it was all right. So how are you going to persuade us that thing, I mean, parking, or putting to one side the actual posts and whether the actual posts here are sufficiently serious, but if they were sufficiently serious, what is your client going to do practically to stop bad speech being disseminated in the way that it can be these days? It's a big concern, I think, to people in our position.
Judge Phillips, indeed, in the 2015 European Court of Human Rights case of Delphi in Estonia, the court held that the intermediary should have taken action even before the court order. But what was crucial in that case is that both the court and the intermediary acknowledged that the content was clearly unlawful, and hence it's reasonable to expect the intermediary to have preemptively censored the content. However, on our present facts, this cannot be said to be the case, because ultimately, Umani speech is not a clear speech of prohibited statements, and hence chatter cannot accordingly be held to the same standard as in the case of Delphi and Estonia.
Are you conceding that if we think the speech was on its face unlawful, that everything worked as it should have under the system?
Judge Crown, we can accept that in cases where it's extremely clear, for instance, maybe recruitment to terrorism, for instance, under those circumstances, chatter should have taken action. But our submission remains that in the present case, the speech was not clear, and chatter is not the best place to determine the legality of such speech.
So it is okay to require them to preemptively police the posts that are coming onto chatter for clear violations?
Judge Bickett, perhaps in cases of very clear instances of hateful or extremist speech, it may be possible, but our argument remains that in this present case for Umani speech, it should not be a standard that chatter is held up to. Because ultimately, requiring chatter to preemptively censor speech is very onerous, given that, yes, while chatter could adopt word filters, these word filters are likely to be under-inclusive, because certain words may seem innocuous, but under certain types of context may cross into the threshold of prohibited speech. But yet these word filters would not be able to capture such statements, and chatter might possibly face a prosecution from the government of Umaria. But worse still, if chatter tried to comply with the obligation by employing word filters, these might also be over-inclusive. And we say so because if we were to look at Umani's posts 1 to 6 and ask ourselves the question of what words could chatter have filtered to satisfy its obligation under both acts, it could have filtered child killers, burn, winner, Umaria, war, armistice, brilliance, but this effectively chills political discourse surrounding the history of Umaria, the armistice that happened, any form of brilliant sentiments on the ground, and this ultimately renders freedom of expression to become the exception rather than the norm, and this is detrimental for individual Umarian citizens' freedom of expression. And hence,
Counsel, I'm sorry, but the chatter is choosing to offer services there, and they understand. I mean, I'm sure they have the smartest engineers in the world, and I don't know a whole lot about this, but I'm sure it would not be too hard for them to triage, use word filters and triage it and have people look at it for the most serious cases. That seems reasonable, doesn't it?
Judge Bickett, unfortunately, around the world today, the only intermediary that employs word filters to preemptively censor speech is Weibo in China. And we know the political ramifications to freedom of expression, because many political discourse surrounding, for instance, political leaders in the country are preemptively censored on Weibo. And this should not be the standard that this universal freedom of expression court should uphold ultimately. But not only is it onerous because chatter cannot comply with such an obligation, I now turn to my second reason as well, which is that the obligation is onerous due to the negative implications on freedom of expression. And under this, we submit that private entities like chatter should not be the ones to censor speech independently, because there's no transparency over how they censor, what they censor. And this is supported by the 2014 United Nations Special Rapporteur on the Contemporary Forms of Racism. And if I may quote, users still do not know exactly what content will be censored removed, or left unattended, given that the platform retains the power to remove posts and content, giving any reason. This lack of transparency has raised concern for users. And we see
I
this.
do have a question on that. So, nowhere in the United Nations or in the European community across the globe, nobody has yet come up with a clear, agreed definition of terrorism. We don't agree what is or is not extremism. Don't we have to provide some leeway for the government to explain in its own historical and current social situation what is or is not this sort of speech? It sounds to me like you're asking for a perfect explanation and a definition of what is or is not the speech before any action can be taken by an internet company.
Judge Crown, indeed there's no universally agreed definition of terrorism for that matter. However, it is precisely because the limits are so untested, we need a democratic and accountable entity to be deciding when speech should be censored and what speech should be censored. And our proposal is that the government is the one that is best placed to do this, because first, there's the electorate check, and second, there's a check through the ICCPR and UDHR as well.
But Councillor, aren't there lots and lots and lots of private organisations that are every day carrying out quasi-judicial functions? eBay, arguments over sales on eBay, for example, is carried out entirely by eBay. And I think a lot of judicial systems would say very well done too, because otherwise they would be swamped with small-scale cases. So isn't there actually a very strong argument that your client should be exercising in as transparent a way as it can these judgment calls?
Judge Phillips, while it is true that intermediaries and companies have been exercising some form of judicial discretion as well, but the question before this court is what should be the position internationally? Whether should it be the government that's accountable and democratic that should be curtailing individuals' freedom of expression, especially in unclear cases, or should it be private entities like Chatter? And ultimately, our submission is that the government is best placed. And we see this model be adopted.
Aren't you trying to have it both ways? I mean, we have a set of facts here upon which you're crafting your argument. In the abstract, you might be able to accept that, but here on post 2, Chatter suspended Umani's account. So they're already acting as judge, jury, executioner of, and policeman of the site. They're not throwing their hands up. They're certainly capable of doing it. I don't understand how your argument squares with that fact that they're actually, your client is actually taking action. But then you're here arguing that it should be the government.
Judge Buck, the suspension of Umani's account for post 2 was not done pursuant to any act or because our client thought that his posts were illegal. And this was because post 2 was made even before the enactment of both the Anti-Terrorism and Extremism Law and No Hate Act. And we may admit that the suspension of Umani's account for post 2 is a mistake and a wrongful judgment that our client should not have made because it should be rightfully protected under the freedom of expression of individuals. And hence, there's no contention between our case on whether intermediaries can and should be regulating such speech. If I may now turn to my second submission on whether the $5 million fine imposed on Chatter was proportionate. We note that the respondents have not made any arguments justifying this $5 million fine imposed on Chatter, even though they have the duty of satisfying all 3 limbs of the 3-part test. Nevertheless, we will provide 2 reasons for why it is unjustifiable. First, $5 million is an unprecedented amount internationally. We look to, for instance, states' legislative maximums, for instance, in the cases of Korea, Kenya, and Thailand. And all these states have a maximum cap of 100,000 USD. Even if we were to afford the respondents a wide margin of appreciation, $5 million is a far cry from the maximum limit in these countries. The second point justifying why the $5 million is disproportionate is because of the devastating effects on freedom of expression if this court agrees with O'Meara. Here we are concerned with 5 posts, and the O'Meara government saw fit to impose a $5 million fine. This means that they think this will lead to 2 possible outcomes. First, Chatter may over-censor speech. $1 million fine every single time it fails to capture one speech that trespasses into the boundaries of prohibited speech.
Excuse me, Councillor, was it clear in the record that it was $1 million per post, or was it a combined total of $5 million?
Apologies, Judge Crown. Indeed, it's not clear that it is $1 million per post, but what we do know is 5 posts were enough to gather $5 million. And for
Right, but
every
in speech, the combination of things matters, and one statement might be nothing. 2 statements together, and by the time you get 5, you actually have something that's quite different than a single statement on its own. So,
And these were magnified. I mean, he has a huge following. And these were magnified by all the reach outs.
they were reposted, they were getting newspaper coverage.
Isn't this more impactful speech? Or means more impactful result, does it not?
Your Excellencies, I see that my time is up. If I may be given 1 minute to address the questions and summarize my arguments. Indeed, there are 5 posts and perhaps they should be viewed together. But what should not be left out also is that these 5 posts were made across 5 years. But for some reason, even though they were spread out and dispersed and interspersed with so many other posts, the Omarian government still saw fit to impose a $5 million fine on Chatter. And $5 million, even if it is for 5 posts consecutively, is still a huge amount. And this will lead to either over-censorship of speech, or Chatter might choose to close down and leave Omaria altogether, like how Google left China and how Prachatai left Thailand. And this ultimately is detrimental for the individual citizens' freedom of expression in Omaria, and hence the obligations in how they were crafted in the statutes and how a private entity like Chatter is expected to regulate speech is onerous and is not something this court should stand for. If I may be of no further assistance, thank you and may it please this court.
May it please this court, Your Excellencies, and the defense. My name is Asmita Singhi, and I, along with my co-counsel, Mr. Rishabh Bajoria, appeared on behalf of the respondents in the case of Umani and Chatter versus the State of America. Your Excellencies, this is a case about a sovereign state trying to prevent the dissemination of hate speech and uphold public order within its borders. The applicants have dragged us to this forum to question activities which, in fact, do lie within our margin of usage. For the first 20 minutes of this court's time, I will address the challenges raised regarding Mr. Umani's right to freedom of speech and expression for both the prosecutions under the No Hate Act and the Anti-Terrorism and Extremism Law. For the next 23 minutes, my co-counsel will address the challenges raised regarding Umani's right to privacy and Chatter's rights subsequently. Your Excellency, freedom of speech and expression is a fundamental human right and forms a central tenet of modern democracies. However, within the scheme of the ICCPR, states are required to prohibit by law advocacy of hatred which rises to the standard of incitement to hostility, discrimination, and violence. As a matter of clarification, posts number 1, 2, and 3 were prohibited under the No Hate Act for inciting hatred, and posts number 4, 5, and 6 were prohibited for inciting to violence. Your Excellency, my first submission is regarding the prosecution for posts number 1, 2, and 3 under the No Hate Act. The applicants have not challenged whether posts number 1, 2, and 3 amounted to the standard of hate speech. However, they did raise 2 objections. Firstly, that because the speech is arguably satirical, it is a form of artistic expression and the court must have some deference. For this, they rely on the case of Alanak versus Turkey decided by the European Court of Human Rights. However, Your Excellency, in paragraph number 49 of that judgment, the court recognized that this is a form of artistic expression which appeals only to a minority of readers. This is clearly distinguished from the case at hand, where Mr. Umani's sorry attempts at rhyming certain words together are being alleged to be forms of artistic expression and is being disseminated in the form of mass communication, and therefore, the insightful value that his speech has cannot be compared to the judgments of Caritas versus Turkey or Alanak versus Turkey, which have been relied upon by the applicants. Your Excellency, the second submission was that there is some level of doubt with regards to the intention that Mr. Umani had. However, we submit that a bare perusal of post number 1, 2, and 3 will dispel these doubts, and I will assist the court in that regard.
Could I just take you back a little bit, Councillor, if I may? Because one of the first arguments that the applicants put to us was about retrospectivity and whether the Act could legitimately apply to old posts that predated the coming into effect of the Act. What does the respondent say to that?
Your Excellency, that brings me to answer the first requirement of the three-part test of legality as enshrined in Article 93. Section A of the No-Hate Act provided on page number 4 of the Moot proposition says that the act of dissemination is unlawful. Therefore, even if the act did not exist when post number 9 and post number 10 was posted online by Mr. Umani, once the act was introduced in 2011, it was foreseeable for individuals like Mr. Umani to know that this speech will be unlawful. Your Excellency, the nature of online speech is thus that once something has been put up on the online forum, it continues to persist, it continues to remain accessible. And as Your Excellency noted, that given the nature in which chatter works, Mr. Umani is conscious of the speech that he has posted.
But Councillor, isn't it just the case that once something's been put out there, it effectively goes into an enormous archive that's effectively hidden behind a closed door that you're only going to find if you really, really actively go and search for it, so that it may have been disseminated at the time, but actually it's long gone from people's memories.
Your Excellency, it is correct that these posts were made years ago. However, given the nature of how the internet works, if a particular American citizen even does a simple Google search of, let's say, villains are child killers because he has some propensity towards these ideas, he can easily access such incendiary material and such hateful material. And this kind of speech, because of the fact that it remains indexed, can be accessed and can be even incidentally accessed. So, which is why we submit that it remains persistent.
So are we to hear then that your client believes there is no retroactive concern that this court ought to have regarding nothing about this being things that happened before the law even came into effect? That is the position of your client?
Your Excellency, yes. This prosecution was not retrospective because the act which has been criminalized is a continuing offense. Jurisdictions, and this is the case...
Excuse me, but it's a continuing offense, but maybe of chatter, maybe of the internet, but not of the person being prosecuted for an act that took place at a particular time, probably a particular minute in the past. How is that not a retroactive?
Your Excellency, the reason why it is a continuing offense even for the individual speaker is because the active use of dissemination is still under his exclusive control in the form of the autonomous chatter handle, which is only under his exercise. Your Excellency, with respect to the mens rea, even if they say that intention needs to be judged in a contextual manner, Your Excellency, intention only flows from the speech in this particular scenario and only the context in which the speech was originally made. The applicant's biggest concern here is a threat of liability, and I will demonstrate to you from the facts of the case why this is an overstated concern. Your Excellency, the Section A of the No-Hate Act applies in a narrow manner. It only applies to individual speakers who engage in speech amounting to hate speech as defined in Section A. Additionally,
sorry, I'm just still on this point, because if they don't know at the time they publish the comment that it's unlawful, because the definition at that point hasn't been put in place, it does seem rather unfair that you can go back and then start looking around to see what you can find in order to put, I mean, isn't the respondent's case better that there's one post that postdates the coming into effect of the Act, and that maybe they should concede that some of the earlier stuff should have been left where it was.
Your Excellency, at this point I will have to rely on the context of the respondent state in this case. Paragraph 9 on page number 4 clearly shows that there is an exaggerated problem of online bullying and online hate speech to the extent that it has led to a number of suicides. If the respondent state wants to protect the rights and reputation of others, which is an enlisted legitimate aim in Article 19, paragraph 3, then the only effective manner of doing this is to make sure that speech which is available online is criminalized in some manner, otherwise there is no incentive to remove the speech from the online forum. Your Excellency, America's internet revolution occurred in 2010. So for all practical purposes, we can understand that this vast growth of chatter or this vast growth of reliance on the internet is only as recent as 2010. The No-Hit Act was introduced in 2011. Therefore, this overstated threat of liability that every individual will have to retrospectively analyze their speech from the very inception of the internet is simply not true, Your Excellency. And therefore, this is an appropriate response to this particular problem that the state of America is dealing with.
Counsel, so there's no limit here. If somebody is a prolific poster, and they have been for years, and some of these posts are actually quite old, even if they post every day 100 posts, they now have to go back through, according to your position, and evaluate each post and consider whether or not they might have to remove it?
Your Excellency, in this particular, for this question, I'd like to draw your attention to the fact that post number 2 and 3 specifically drew a large-scale outcry from the American society to the extent that Umani's account was taken down for a day.
But my question is, should there ever be a limit? Should there ever be a limit here? Or is your position that people should always have to go back, even if they are very frequent posters, and evaluate whether or not their post should now be removed?
Your Excellency, given the fact that the determination of mainstream intention, this is not an onerous burden because individuals are not only retrospectively analyzing their speech, there's also determination of whether they have an intent at that point. And therefore, there are adequate safeguards, Your Excellency.
But we just heard from the applicant that there was no direct evidence, of course, of intent. There are only these others. I would assume that the government takes the position it is free to pass new laws in the future. And so hypothetically, every day there could be a new law with a new set of illegal pieces of content. And a blogger then is under a requirement to review everything that has ever been posted under an increasing number of definitions of illegal content. That's what your position leads us to?
Your Excellency, that is an extreme end of what we are trying to submit to this court. The only reason why this is a necessary measure in the American state is because of the specific context, where the only way to solve this problem is to allow for online speech to be seen as a continuing offense. Unless there are such pressing conditions wherein the state has to exercise its margin of appreciation, we do submit that the responding state will not adopt such laws. Your Excellency, with respect to the fact, we now come to justify the necessity of this restriction. The applicants have challenged sentencing of 2 years for Mr. Umani as extremely disproportionate. It is necessary to recognize that Mr. Umani is not any other American citizen. He is the Deputy Justice Minister. And in this case, by relying on abusing his right to anonymity, he has essentially tried to spread propaganda against the brilliant individuals. He is adequately aware of the exact problems that the American state is trying to solve, which is increasing active terrorist activities, increasing ethnic conflict between these two societies. Your Excellency, his identity was disclosed to the American citizens, and therefore, and it is well recognized by various cases from the European Court of Human Rights, that political officials do have an added responsibility to ensure that they do not become mediums of hate speech. And therefore, it is important that this special context needs to be addressed in a proportionate manner. It is important.
Can I ask the respondents, what is the respondents' attitude, at least as far as Mr. Umani is concerned, about anonymous speech? Does the respondent take an absolute view on anonymous speech is bad, or does it think that there are situations when it can be permitted and should be permitted? Because I understand that the respondents also got an order in this case to force the revelation of Mr. Umani.
While my co-counsel will be addressing this claim specifically, we submit that anonymous speech is not an absolute right. And in scenarios when there is a pressing need to balance another right, for example in this case to uphold the public order in the state, then it becomes necessary to give up the right to anonymity.
Counselor, something you just said leads to one of my concerns. You said you referred to public order within the state. I assume you would agree that the government's interest is in order within its own borders. Is that correct? So what I'm concerned about is that the country immediately next to Omeria, Brenna, seems to be the target of some of these posts rather than, say, the ethnicities or the ethnic enclaves within Omeria's borders. So is the government trying to criminalize speech where the target of the speech is outside of the country? And is that proper?
Your Excellency, we submit that there was a real risk of violence within the Omerian borders as well. And this brings me to my second submission regarding post number 4, 5, and 6 under the anti-terrorism and extremism law. The applicants have challenged that there was not a sufficient risk and there was a lack of cause relationship. However, Your Excellency, let us analyze what Mr. Romani is doing over here. On April 19, he jokes about the possible vanishing of the Britons on another armistice anniversary. As we get closer to the armistice anniversary, on May 22nd, his posts become even more severe, where he is calling upon every Omerian citizen to do their part in purification, and ascribes this not to his own individual self, but to the Omerian state by saying that your leaders will handle pardon you. Your Excellency, this kind of speech on a social media platform is extremely dangerous because social media platforms have a mobilizing effect where Mr. Romani does not even have to go forward and look for people who may be sympathetic to his cause, but people like the night watcher will by themselves align themselves to this cause. And therefore, close to the armistice anniversary, this speech was dangerous for the Omerian citizens, including the ethnic Omerians as well as the ethnic Britons. And the facts...
I do have a question on that, though. I think the record indicates that, in fact, no violence occurred following this. We have a criminal prosecution and a verdict based upon the effect of this speech when we have in the record that there was no violent effect. Can you speak to that?
Yes. Your Excellency, incitement to violence is essentially an inchoate crime. Therefore, the analysis of how dangerous the speech was should be an ex ante analysis and not an ex post facto analysis. And Your Excellency, when it comes to punishment of Mr. Romani, there are a number of factors which become important, which also include the mens rea. For example, in the case of Zana versus Turkey decided by the European Court of Human Rights, it was held that because Mr. Zana was the ex-mayor of the particular area in consideration, he must have realized the necessary impact his speech would have. And therefore, 12 months of imprisonment was considered proportionate. Now, the applicants may try to distinguish this case by saying that Mr. Romani was acting anonymously. However, the facts show that Mr. Romani was speculated as a high-level government insider. He had 800,000 followers, and which also rechatted what he said. Your Excellency, furthermore, not only did he speak these things in his personal capacity, he ascribed them to the state, and this could have dangerous consequences within the Omerian society. Your Excellency, now I address the challenges raised regarding the alleged overbreadth of the anti-terrorism and extremism law. As a matter of clarification, the scope of inquiry before this court is not the entire domestic legislation of the state of America. And if I may read from the case of Forson in France, decided by the Human Rights Committee, it says that the committee is not called upon to criticize in the abstract laws enacted by state parties. The task is to ascertain whether conditions of the restrictions imposed on the right to freedom of expression are met in the present case. Therefore, even if, and this is their only challenge, that because there is no prescription or no ceiling of what the civil penalty and criminal penalty would be, they have to show that that overbreadth was exercised in this present case. However, Your Excellency, 2 years of imprisonment for 2 separate offences and 2 extremely grave separate offences is not a disproportionate response given the particular context of the respondent state. Therefore, even if there is no express ceiling in the provision, they have not demonstrated how the respondent state has abused that in the present case. And therefore, Your Excellency, the challenges regarding, and we submit that the fact that this section provides for civil and criminal penalty is sufficient for Mr. Umani to foresee that an offence may attract criminal penalties.
But isn't there an issue that the applicants touched on here, which is around certainty and knowing? And in a way it feeds back into the retrospective concerns that you've already expressed. But if you've got a retrospective, potentially ever-reaching retrospective act combined with a situation where you really have no idea what sort of penalty you might face from actually the whole, again, range from a civil damages award all the way through to 10 years imprisonment, that has an extraordinary chilling effect on free speech, and it's just far too wide.
Your Excellency, with respect to whether the retrospective application would in fact call a chilling effect, we submitted that would not be the case. If the applicants who have agreed with us on this point have not challenged whether Section A was overbroad or not, they agree in principle that it is sufficiently precise to regulate future behavior. And we demonstrated to this court why the threat of liability for retrospective application is overstated. In that case, retrospective analysis of whether speech is lawful or not under Section A should also, therefore, not cause a chilling effect.
Just in respect of the applicants, I think their argument was if the definition were precise enough, then it might work. But even on these facts, their position is that these don't meet the standards set by which you have that stuff. It feels you're a bit misstating what the other side is arguing.
Your Excellency, I'll submit my argument separately with respect to both these laws. We have 1 more minute. Laws may be worded in a slightly vague manner to allow for flexible application and so that they do not become irrelevant over time. The anti-terrorism law was introduced to address a very specific and exaggerated problem in the American state, and therefore it is fit for it to have the flexibility of allowing civil as well as criminal punishment. Your Excellency, with respect to the No Hate Act of 2010, the challenge is that this is retrospectively applying, and we demonstrated how the only speech which may actually be requiring any review would be from 2010 to 2011 at best, and because the Section A is precise, retrospective analysis also would not cause a chilling effect, and 10 years is sufficient deterrent effect for people to actually follow this law. Your Excellency, it's been a pleasure. My co-counsel will now submit to respond.
Here on behalf of the respondent, I will be dealing with the issues raised regarding Umani's right to privacy as well as the intermediary chatter's rights. First, I will submit that the court order which led to the revelation of Umani's identity did not violate his right to privacy under Article 17 of the Covenant. Second, I will submit that the imposition of liability upon chatter for posts 1 and 3 under the No Hate Act and for posts 4, 5 and 6 under the Anti-Terrorism and Extremism Law did not violate its right to impart information under Article 19 of the Covenant. Your Excellency, with regard to my first submission, the relevant facts can be found in paras 16 and 17 of the Moot Court proposition. Your Excellency, it can be seen that there was a large public outcry in the media in response to posts 4, 5 and 6, and pursuant to this, the government moved to court under Section 6 of the Anti-Terrorism and Extremism Law and obtained an emergency order. This emergency order mandated chatter to reveal the identity of the person behind the Vigilante Insider's account. Eventually, after a week, chatter gave up this identity and the state subsequently prosecuted this person.
Counselor, I'm actually troubled. I'm glad you brought that up. I'm troubled by the fact that the government only brought the prosecution after this public outcry. Doesn't that seem to suggest that the law is vague and can be applied capriciously? That seems to point towards the applicant's favor, that They don't know when and where they might be subject to the whims of the government in that regard. And they're reaching back. The government's reaching back many years in some instances to posts that were made quite a long time ago. So why is this not a capricious application, simply following a public outcry, a political prosecution?
Your Excellency, firstly, with regard to the posts that date back over 4 to 5 years, Your Excellency, with regard to those posts, they are being prosecuted under the No Hate Act, and there was no provision under the No Hate Act which would allow for such disclosure of identity. However, the posts which were impugned in the public outcry, i.e. posts 4, 5, and 6, Your Excellency, as soon as these posts were made, pursuant to the public outcry, the state did move. However, the fact that there was a public outcry simultaneous to the state moving to court does not show that the law itself is overbroad. And I will demonstrate to you how the law, and specifically Section 6 of the Anti-Terrorism and Extremism Law, is in fact sufficiently foreseeable and precise. Your Excellency, our arguments in this regard can be found on page number 22 of our written submissions, where we dispute the fact that there was any interference with privacy at all, based on the third-party doctrine developed by the United States Supreme Court in Smith versus Maryland. However, in any case, we would submit that even if there was a restriction, such a restriction was permissible as it fulfilled the three-part test of legality. Your Excellency, the first limb of the three-part test concerns prescription by law, and in this case, the restriction finds basis in Section 6 of the Anti-Terrorism and Extremism Law, which can be found on page number 4 of the Moot Court proposition. Your Excellency, this provision clearly says that upon application and sufficient showing, a court may issue an emergency order to remedy violations of the Act. Your Excellency, a few things must be noted here.
Councillor, could I just interrupt? I'm not sure where it comes into the respondent's case, but as my understanding on the facts, again in this case, at some point your client handed over the name of Mr. Umani to the media. Does your client say that is justified by law?
Yes, Your Excellency. And in that regard, we would submit that that would again flow into the necessity analysis. However, just to answer your question, Your Excellency, we would submit that the two rights that would then need to be balanced would be the right to know of the public versus the right to confidentiality that might exist for Mr. Umani. However, given the fact that Mr. Umani is a publicly elected official who is engaging in such diatribes and is engaging in speech which incites hatred and incites violence, we would submit that this public interest in knowing about the actions of their elected officials is in fact extremely grave.
But Councillor, isn't it the case that at this stage, all that they knew was that it was Mr. Umani who was behind the posts? At that point, there'd been no prosecution. So the fact that he was guilty of criminal offences had not been determined. Would it not have been more appropriate to have left naming him until the criminal prosecution process, for example?
Your Excellency, two responses to that. Firstly, the government at no point of time, even when it revealed his name to the media outlets, gave a verdict of guilt or innocence with regard to what he had done. All it did was...
It created a public clamour. We've just heard it created a public clamour.
While that is true, Your Excellency, we would submit that the overriding public interest here would be extremely important. This was noted by the European Court of Human Rights in the case of Craxi versus Italy, where it said that this right to confidentiality with regard to trials cannot be absolute. And given that there was no public trial as such carried out, but only the name of the person behind the account was revealed, we would submit that there was no interference. Furthermore, Your Excellency, we would submit that in this case, it was pivotal for the government to reveal the name of this person, given that this person was using the Vigilante Insider's account to incite extremism and incite terrorism. And in that case, it would be pivotal for the people to know who is behind such acts. And as a result...
Excuse me, you are then arguing that as soon as the government suspects somebody using an anonymous account of inciting violence, their right has been yielded because of the suspicion, and perhaps because they have a public office?
No, Your Excellency. With regard to how their right to privacy actually works, rather than bring me to the crux of my necessity analysis, we will submit that while the right to anonymity is extremely important in a democratic society, especially the right to anonymous speech, as the European Court of Human Rights noted in KU versus Finland, this right to anonymous speech cannot be absolute and must be balanced against the positive obligation placed upon the state to prevent crime and disorder and maintain public order in society. Furthermore, Your Excellencies, it has been noted by a number of UNGA resolutions, including Resolution 55/63, as well as Resolution 63/121, that in an age where there is a burgeoning amount of anonymous criminals on the internet, it is pivotal that states have access to electronic data so as to track down these criminals. However, Your Excellency, we would submit that the right way to do this is through a court order standard, whereby a state can only obtain the identity of a person after a judiciary has carried out effective control and has balanced the competing rights and interests. Your Excellency, this has been recognized by the Canadian Supreme Court in R versus Spencer, as well as in the United States Legislature in the Electronic Communications Privacy Act, which says that a court order must be obtained before the revelation of IP addresses. As a result, Your Excellency, we submit that the restrictions do meet the three-part test of legality, and there was no violation of Mr. Rumani's right to privacy. Your Excellency, moving now to the intermediary, chatter's rights. First, I will address the intermediary's liability for posts 1 and 3 under the No Hate Act, and then I will address its liability for posts 4, 5, and 6 under the Anti-Terrorism and Extremism Law. Your Excellency, the applicants have erroneously assumed that we are imposing a standard of strict liability upon them. However, Your Excellency, I would point your attention to para 16, line 1 of the Moot Court proposition, which clearly says that Chatter had received several complaints about Rumani's posts. Your Excellency, it has been held by the CJEU in the case of Sebam versus Netlog in para 27 of his judgment that social networking platforms do qualify as hosting service providers under the E-Commerce Directive 2000/31.
So counsel, what is a social media platform's obligation if somebody emails them to complain about a post? I mean, presumably Chatter gets many such emails or user complaints.
We would submit that the obligation upon the intermediary would then be to investigate the validity of those complaints and see whether or not this speech is legal or illegal. We submit that this is not an onerous burden to place upon them, as intermediaries are already doing this widely. For example, YouTube has a dedicated notice and takedown mechanism, whereby once a video is reported to it, it has a team of not just peer review, but also a mechanical system, whereby it investigates into the nature of the complaints and sees whether or not certain videos violate its terms of services.
Its terms of services?
Yes,
but is Chatter responsible for understanding all the laws in all the countries where it operates and having all of its employees understand that as well?
Your Excellency, in this case, two responses to that. Firstly, the factual response would be that we are only told that Chatter works within the contours of a media. And we would submit that it would be the obligation upon Chatter to know Omedia's laws, and given that it is already making evaluations of speech as to whether or not it is acceptable or not acceptable, it can make the evaluation in the terms of a legal context also. With regard to...
Just pick up on that point. I mean, what standard is the respondent saying that Chatter has to apply here? Is it going to apply a US First Amendment standard? Is it going to apply a European standard, which is a lower threshold in these cases? What standard is the respondent saying that Chatter has to apply?
Your Excellency, the respondent's case is that an intermediary should be liable to take down content upon receiving actual knowledge. This standard flows not just from the EU Directive 2000/31, which is implemented in the European Union, but also in other jurisdictions such as Australia and New Zealand. Your Excellency, with regard to your previous question about Chatter having the burden to know the laws of the laws across nations. Your Excellency, it was held, in fact, in the recent case by the Belgian Supreme Court that if Yahoo is operating within its borders, it takes upon itself the burden to know the laws of that country and to then implement those laws, to some extent at least, on its speech when it receives actual knowledge. Your Excellency, it's really important to clarify that the respondent state is not imposing a general monitoring obligation upon the intermediary, because we realize that such an obligation would be an onerous burden. However, all we are saying is that upon receiving notices, chatters should be able to investigate into these claims.
Excuse me, but as I recall, part of the impetus for these laws in the first place was, especially the no hate, was internet trolls and the problem that you were facing in the country. If the position of the government is that upon receipt of notice, content must be taken down, that's a strong incentive to trolls to attack every bit of speech that isn't perfectly aligned with the position they would like. And I think I heard you say that upon receipt of notice, it has to be taken down, or there is, and I don't like to use the word strict liability, but it sounds like if you don't do it, and if you got it wrong, you are liable and should be subject to these sorts of fines.
Your Excellency, we submit that the imposition of such a standard would not result in a blanket removal of speech as soon as an intermediary receives notice. The reason for this is because even intermediaries will know that if they censor so much speech on the internet, and if they take down every post that a user puts up which it is complained about, users will then not want to use their website.
I'm sorry, Counselor, that sounds like an argument for disobeying the law because it's at war with a business interest, as opposed to the law is clear as to what a company should do.
Your Excellency, to clarify my position on this, our submission is that the intermediary would then have a market incentive to narrowly tailor their restriction. This has been noted by...
Counsel, if we want to talk about market incentives, I'm sure it's very expensive for Chatter to maintain both the infrastructure to receive reports from consumers and then also the employees who review those. Aren't we giving them an incentive by this law to play the ostrich and to make users go through a complicated form to contact them, or remove the ability, as I know some social media platforms don't really have an ability for people to contact them. Don't we want to give them a business incentive to allow people to contact them?
Your Excellency, while we do acknowledge the importance of this right, we would submit that once again, this right to impart information of the intermediary must be balanced, and it must be balanced against the state's positive obligation once again to maintain public order in society. For example, in the case of Belen Rodriguez versus Google and Yahoo in the Argentinian Supreme Court, the court held that while a judicial order standard, as my learned friends have argued, might be appropriate for certain kinds of suits, for example, for defamation suits or for copyright infringements. However, in cases of gross harm, which result, an example of which is speech which incites hatred or speech which incites violence, the correct balance will be struck if a private notice standard is implemented. Your Excellency, the reason for this is that, as was noted in para 110 of the courts of the Grand Chamber's judgment in Delphi versus Estonia, the harms of hate speech are in fact magnified on the internet. The reason for this is because, firstly, of the wide reach that the internet gives this speech, and secondly, the persistence of that speech. As a result, Your Excellency, we would submit that when we look at the context Your Excellency, as I was explaining, to reach an evaluation of what the correct standard of intermediary liability is, a balancing test must be done. A balancing test between the intermediary's right to impart information versus the state's positive obligation to maintain public order and prevent crime and disorder in its society. Your Excellency, the fact that there is no consensus on intermediary liability across jurisdictions shows us that this balancing test must in fact be contextual. And when we look at the context in our case, whereby Omedia is facing mass hostility and violence between two groups of people, whereby there is borderline ethnic cleansing on the borders, whereby this problem.
Counsel, so what constitutes actual knowledge if you are a chatter? Is it enough that somebody sends an email to their press@chatter.com email address? Is it enough that somebody sends a user complaint even if they receive millions every day? When do they have actual knowledge?
Your Excellency, once again to clarify, we would submit that chatter would have actual knowledge as soon as it receives complaints about the post. The logic behind this is that even an email sent to chatter about a particular post would qualify as actual knowledge.
An anonymous note under the door, a phone call, mentioning the post on December 23rd at 10 a.m. I mean, what, or does it have to be through their user complaint mechanism?
Your Excellency, we would submit that no matter what the method of the complaint might be, the underlying rationale for this is that chatter must be made aware of the content. However, we would acknowledge that absolutely general complaints, for example, if there is a complaint simply about a Vigilante Insider account, we would agree that that would not amount to actual knowledge, as it would then have to go through all of the posts of the Vigilante Insider. And so the complaints would have to be specific to posts. However, we would also draw Your Excellency's attention to para 122 of the case of L'Oreal versus eBay in the Court of Justice of the European Union, where the court held that even if there isn't a specific complaint which meets the impugned criteria, even if there is a simple complaint, that would definitely play a massive role in the analysis of whether or not an intermediary had actual knowledge.
But so just picking up on that, I mean, following that through, actual knowledge of what? So who's going to determine, for example, if someone writes and says this is unlawful hate speech, have chatter got to take that as it is?
Your Excellency, we would submit that, for example, if somebody sends a complaint to chatter about post number 4, saying that this content is hate speech, it is then chatter's obligation to go ahead and investigate that post and look into, and Your Excellency, we would submit that this is not an onerous burden, given that intermediaries across the world already have mechanisms specifically dedicated to this, whether it be, yes, Your Excellency.
Councilor, but isn't this the problem? We're really getting too granular here. You have someone on the one hand whose account, if they're looking at the post or looking at the account bio, says he's a political poet. I mean, how much context does chatter have to bring in? And then isn't this all too complex at the end of the day? Isn't the simpler solution to allow more speech to counteract the speech that has been complained about, which seems to have occurred? I mean, it could occur on chatter. It occurred in the newspaper, a traditional a form of news media. So isn't the system self-regulating in a sense already?
Your Excellency, two responses to that. Firstly, while we do understand that the procedure that we are proposing might be complex to some extent, however, we would submit that that complexity is required in the given context, given that the harms that can accrue from such hate speech. Your Excellency, we would submit that to impose the standard that is to impose a standard from Section 230 of the Communications Decency Act would be extremely harmful in a state like Omeria, where there is already so much harmful content on the internet, and where the situation is already so volatile. And once again, when we do this balancing act, we see that because of the threat of public order that exists, there must be a slightly greater curtailment of the intermediary's rights as opposed to other jurisdictions, such as the United States, where there can be this scope of speech and counter-speech. However, in a case where there is such targeting of a certain minority, that minority's ability to do counter-speech would definitely be under question. And for more than that, more fundamentally, the fact that there would be such a large amount of speech targeting that minority would incite hatred and would have the possibility of inciting violence against that minority. Given the harms that accrue from this, we submit that it is the state's positive obligation in this case which would outweigh the intermediary's rights to impart information. And
I do have a concern I'd like you to address, and that is, you brought up that it wouldn't be burdensome for the company for chatter to do this. if it's not so burdensome, one argument might be, well, the government ought to provide the resource. Why put that burden on the company? And the reason I would posit that might make more sense is because as a rational economic actor, the discussion we've had so far tells me that Chatter's not going to know with certainty whether something does or doesn't violate the law, and they're subject to $6 million fines. Won't that inevitably have a chilling effect on speech in the country?
Your Excellency, 3 responses to that. First, we submit that intermediaries are the most effective point of control over the internet. It is not possible for a government to go ahead and regulate all of the content and monitor all of the content on the internet as there is just too much of it.
But excuse me, but why the government is a larger entity presumably than Chatter in the country, and why wouldn't we just direct all mail? It also flows through where the government has access. So, as to a practical, that's not the argument here. The argument I'm concerned about from a human rights perspective is chilling speech. And how do we address the risk that what you've so far articulated will in fact lead Chatter to be very cautious if something comes in and we simply should take it down, and they won't in fact provide all of the sorts of oversight that we would hope in order to have vibrant protection of the freedom of expression, which, by the way, is not just the freedom to express yourself, it's the freedom to receive information as well. So we're having that effect on the citizens here.
Your Excellency, given that my time is running out, I will seek a small extension. Your Excellency, first, once again, coming back to your first question regarding why the government shouldn't be doing this. For example, there might be 10 other social media platforms like Chatter, and it would be impossible for a government to go ahead and monitor all of them. Instead, it is far more efficacious, as various academicians have noted, that the intermediaries should be held individually liable. And given that they are monetarily benefiting from the content on their website, they should also be monetarily liable when they fail to exercise this right responsibly. Your Excellency, with regard to your question about the possible chilling effect that might occur on the internet because of the threat of liability, Your Excellency, we would submit that once again, the burden upon the intermediary would be just as same as the burden upon a normal individual to then decide whether speech is legal or illegal. So a certain amount of self-censorship is in itself inherent to any legal process. For example, if the No Hate Act criminalizes speech which incites hatred, that means that if I am a citizen in Omeria, I must self-censor myself to the extent that I do not go out and commit speech which does incite hatred. So, Your Excellency, we submit that this is not an onerous burden. If I could quickly summarize my submissions regarding restrictions, despite my time being up. Your Excellency, we submit that in this case, the restriction finds basis in Section D of the No Hate Act, as well as in Sections 3 and 4 of the Anti-Terrorism and Extremism Law. Your Excellency, my learned friends have erroneously argued that facilitation means a general monitoring obligation upon the intermediary. However, once again, I would take your attention back to the case of Robert Forreston versus France, where it said that the scope of inquiry before this court is even if there is overbreadth in the law, whether or not that overbreadth was exercised. And in this case, liability is only being imposed upon Chatter despite not acting upon private notices. In fact, for the one post that it did act upon a private notice, no liability was imposed on Chatter. And this shows that there is clearly a notice and takedown standard which is being imposed upon Chatter and not a general monitoring obligation. Furthermore, Your Excellency, Section 3 and 4 of the Anti-Terrorism and Extremism Law, read together, would say that any social media platform which publishes statements which incite extremism would be liable. An intermediary can be deemed to be publishing these statements after it takes secondary responsibility for these statements, despite not taking them down after receiving a notice. As a result, Your Excellency, we submit that the restriction was permissible.
Mr. President, Your Excellencies, 3 points in rebuttal. First, the entire case of the respondent for Chatter is based on the obligation of user complaints. We have 2 responses. First, where exactly in the statute, borne out on the wording, is this notice and takedown regime? We submit that it is not present, and the respondents have avoided this by conveniently using one 1996 case of Forreston and France 2 Directors Court to look at the application. The second response is Even if the obligation was one upon receiving complaints, what should Chatter have done when it received complaints? Should it censor the speech because it is afraid the government might prosecute it for every one failure to remove posts? Or should it choose to protect the speech, to protect its customers and their freedom of expression? This is ultimately a dilemma that the respondent state has placed Chatter in that is oppressive and onerous. Turning then to my second point in rebuttal, the respondent argued that Section 5 of the Anti-Terrorism and Extremism Law, which allows for criminal and civil liability, is prescribed by law, as we should again look to the application using that one 1996 case of Forison and France. 2 points. First, this is misapplying that case, because in that case, they were dealing with a statute that contained different possible interpretations of certain words, and hence the court directed the court to look at the application instead. But here, we have clearly unambiguous words that says that the state can impose criminal and civil punishment, and hence there's no ambiguity and there's no reason to rely on Forison and France. But the second response is this. If we take the respondent's argument to its logical extreme, it means all states can pass broad laws and say, look at the application instead. This ultimately makes a mockery of the first limb of the three-part test, which is whether the law is prescribed. Turning then to my last rebuttal, the respondent also argued that the prosecution under the No-Hate Act for Post 1 and 2 are not retroactive because disseminate is a continuing offence. We note that Judge Phillips, Judge Crown, and Judge Bickett all expressed concerns over the onerous nature of such an interpretation. And this concern is valid for 4 reasons. First, when Umani published his post, he could not reasonably have foreseen liability. Second, this means that when the No-Hate Act was published, everyone who has such prohibited statements immediately incur liability because they are continuing the offense by disseminating such speech. Third, they are expecting individuals to throw through every single one of their posts that they have made on social media, something that is very onerous and oppressive, especially because the statute does not even make this clear. Mr. President, Your Excellencies,
you can have 1 more minute if you want.
Much obliged, Mr. President. And the last point I would like to make is that this retroactive application makes it even more onerous for Chatter, because we're not just concerned with one individual Umani, but also the intermediary who has to throw through all its users and all their posts to ascertain whether any of them breached the law. If I may be of no further assistance, thank you and may it please this court.
Your Excellency, first addressing the applicant's challenge to the application of the case of Robert Forison versus France. Your Excellency, this is simply an example, and there are multiple cases saying the same thing. And the reason for this is because this is not a court of 4th instance, which is going to sit and apply domestic law. Domestic law is to be applied by domestic authorities. The scope of inquiry before this court is whether or not the application of such law upon the individual violates his rights under international law, i.e. his rights under Articles 19 and 17 of the Covenant. If I may read from the concurring opinion in Robert Forison versus France, para 2, I would like to add that a determining factor for my position is the fact that although the wording of the Gay-Sort Act might in application constitute a clear violation of Article 19 of the Covenant, the French court which tried Mr. Forison interpreted and applied that act in the light of the provisions of the Covenant, thereby adapting the act to France's international obligations with regard to freedom of speech and expression. Similarly, in this case, even if this court is to accept the applicant's claims that the law might be overbroad, it is still their burden, which they have failed to discharge, to show to this court how the application of this overbreadth has happened in this case, and how such application has violated their rights under the Articles of the Covenant. More importantly, Your Excellency, they spoke of how the notice and takedown regime is not codified in law. However, Your Excellency, we would rely on the case of Sunday Times versus the United Kingdom, which said that laws must sometimes inevitably be couched in somewhat vague terms and can be open to judicial interpretation. Furthermore, in the case of Delphi versus Estonia, the court held that when it comes to applying laws to legal persons, the margin of appreciation afforded to states is larger because, if I may just have 15 seconds to complete this, because it is assumed that such big legal persons and corporations have greater access to legal resources. As a result, Your Excellency, we submit that there was no violation of any of the Articles of the Covenant. It is indeed with pleasure.
The public audience is now over. The court will retire and consult, and you will be informed of the result later.